Barnhill.
Your Honor, Mr. Barnhill is present and approaching. Judge 23 CF 1308, 24 CF 496. Judge, we just filed a motion to withdraw due to a conflict of interest, Your Honor. We sent your office an order through the portal, so we'd request to withdraw. He probably would need to plead not guilty on the new charge and leave this set for pretrial.
Charged with dealing in stolen property.
Indeed, Judge.
So I'll be probably appointing conflict counsel for you.
Yes, sir.
His next court date would be April 22nd. Okay? Isaac Cowboy. Mr. Cowboy, this is Raymond, 24 CF 529. You're charged with 10 counts of possession of obscene material. Would you like me to appoint you a public defender to help you out and represent you?
Yes.
Okay. I'll appoint public defender's office.
Your Honor, Tim gives on behalf of Mr. Isaac Cowboy. Judge, will enter a plea of not guilty and leave this set for pretrial.
April 22nd.
Man trial by jury and request 15 days for any pre-arraignment motions.
All right, thank you, sir.
Thank you, Your Honor.
Terry Campbell, 24 CF 495. You are charged with smuggling contraband into a prison and possession of narcotics equipment.
I have an offer, Your Honor, for Ms. Campbell, is to plead as charged, adjudication of guilt for time served and court costs.
Okay.
She has prior felony for.
If you want me to, if you want to accept that, I'm going to adjudicate you guilty and send you to time served and court costs, and you'll be out.
Yes, ma'am, I do that, sir.
Okay.
I get that, do that.
Would
What
you
about, what
part-
about the charge that, the misdemeanors I had?
I don't know about those.
It's a felony, smuggle
I'm
contraband.
talking about, I had a felony. They said I had a felony charge today.
This is a felony.
I'm a misdemeanor, I mean.
You are charged with a misdemeanor and a felony.
Okay. So all this together, right?
Yes, ma'am.
Yes,
Okay, I
ma'am.
understand. Okay, I do that. I will do that.
All right,
Thank
would you raise your right hand to be sworn? Look at me,
Look at the judgment.
Okay, sir.
your other right hand.
Oh, sorry. Okay.
Swear the testimony you give forth is the course of truth, so help you God?
Yes, sir.
You want to enter a no contest plea to smuggling contraband into a prison, which is a third degree felony, and possession of narcotic equipment, which is a misdemeanor. You want to enter a no contest plea to those charges, correct?
Yes, sir.
You can put your hand down.
Yes, sir.
Are you aware of the rights you're waiving by entering this plea? Your right to a trial, right to an attorney, right
Yes,
to
sir.
remain
Yes, sir.
silent, and
Yes, sir.
other rights?
Yes, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it. Judge you guilty, sentence you to time served. Standard court costs, I'll give you 180 days to pay it before it goes to judgment.
So how much the court cost is?
$615.
$600? What, 600?
It's $515 plus the $100, right?
615.
Okay.
So can I, so
515.
can I pay some of, because I work here
I'm
at
gonna give you
part-time.
180 days to pay it.
That's, how long that is, that's 4 months, right?
6 months.
Okay, I got you.
So, you can pay it at the clerk's office downstairs.
I can pay here little at a time, right?
If you don't pay it, it goes to a judgment.
Okay. So y'all won't pick me up if I don't pay, right? Okay,
No,
thank you, sir.
I won't pick you up.
I'm just saying, the police, will they pick me up if I don't pay the fine? Because I work, but
It may have effect on your driver's license.
but
so
I don't
you-
have a driver's license or nothing, none of that.
Well, just go, you don't want a judgment on you though, because if you,
Okay, but I pay a little at a time, that's all I can do.
yeah, you
'cause I
pay a
can't-
little at a time.
Okay, thank you, sir.
They can do a payment plan with you. Talk to the clerk about that.
All right,
May I approach with the score sheet?
I thought she was here. I see you at home.
I see you, because I'm heading there now.
All right.
Okay, look, this is not some game show or something. Oh, and I order you not to break the law anymore, too. Okay. Naomi Cantrell. Naomi Cantrell.
Your Honor, Tim Gibbs on behalf of Ms. Cantrell. I don't see any response from the court as the court sounds her name.
We'll call her back in a minute.
Very well, thank you, Judge.
Winona Carpenter.
She's been there.
Like,
What you do?
this is a VOP. This is she had a machete in her back while she was being arrested on this.
This is 24 CF 524 State versus Winona Carpenter.
30 days.
You're charged with possession of a weapon by a convicted felon. I think that's a second-degree felony. Is there an offer for her?
Yeah.
Oh, she's represented by a public defender.
Yes.
Yes, Your Honor. Tim Gibbs on behalf of Ms. Carpenter. Judge, we just got a new offer from the state through negotiation. We're trying to see if we can resolve it.
I'll bring her back next week in April.
Judge, the issue that she has, I don't know if the court's aware, if the court can see the scar on the top of her head. She's recently had to have brain surgery due to an attack that happened on her while she was out in town. She's been having a lot of health problems because of that. We're trying to negotiate it out so that she can, she's supposed to be released on misdemeanors tomorrow or Saturday. We were trying to negotiate the case out. I don't mind bringing her back. But the most recent offer, Judge, is for 30 days in jail with this charge. She's got about 3 weeks in, so she's almost close to that time being finished.
It's just the jail won't give me my medication. I told them this was bleeding.
Can we approach Judge for a
Yeah.
second?
Of Powell Injury Law for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law. 850-306-2667.
Cyclone Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade.
I'm sorry.
You want to enter a no contest plea to that charge?
Is that a yes, Ms. Carpenter?
Yes.
Are you aware of the rights you're waiving by entering a no contest plea to this charge?
Yes.
Has anyone forced you or threatened you to enter this plea? So are you been forced or threatened to enter this plea?
No, sir.
Are you happy with the work Mr. Gibbs done for you on your case?
Yes, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it. Sends you to time served.
You don't need to sign
All right,
anything, ma'am.
thank you.
No.
Adjudicated guilty.
Thank you, Your Honor.
So who we got? Mr. Johnson? Okay. Javis Johnson?
Yes, Your Honor, this is a fugitive from justice case. I don't know the status of his extradition. If it's not resolved yet, I would ask to continue the case for 30 days. maybe until it gets picked up.
What state are they trying to after him from? Go get you out on bond if they don't come get you within 30 days.
Yeah.
Yes, sir. Today's my 28th day.
28th?
Yes, sir. I signed February 27th. And I don't understand because I got extradited from Tuscaloosa to Okaloosa County Jail. And the database hit for NCIC a week after I got processed in Okaloosa County Jail.
You got
The
extradited
warrant is from
here?
Alabama, Judge.
Pardon?
That's what I have. The warrant, the extradition is from Alabama. See, Judge?
Judge.
It's Alabama.
Hang on just one second. I think you're thinking Jim. This is Chambers.
Yeah, I've got Javers.
It's 24 CF 505 Javis Johnson.
Javers Johnson on a set for pretrial.
What's the DOB?
DOB, 179.
Same thing on both.
Yeah, same DOB.
Judge, actually, it looks like I've got him on a case that's already pending before the court. It would be a kid's house case, a child abuse type case. So obviously, I don't want to have him brought back down again from Alabama, but we do want to try to get his case resolved. Tim, what are you showing as his next court date?
So in 23 CF2 pretrial conference on April 22nd. And that's his next court date. And then the charge today is the fugitive from justice, like Ms. Leon said. So I don't know the status. I don't know if he signed his waiver of extradition.
All right, well, he does have Florida charges pending, so April
He does.
22nd.
What I'll do is I'll come out, we'll talk about the Florida charge and see if we can get it resolved so that you can go back.
Even if
Has he signed a waiver of extradition already?
He has.
All right, then once that case is over with, assuming that you're not sentenced to incarceration here in Florida, you'll be able to go back to Alabama. They'll have a hold on you, we'll have to pick you up. Okay, if they don't pick you up, then the judge's going to have to give you a bond on it.
even if I already paid my bond here, I just paid $5,500 February 27th
For
for this case in
for
Florida.
for the Florida case?
Yes, sir.
Yeah, Judge, in that case, I'm going to ask that the court let him bond out on the extradition, although if he signed a waiver of extradition, there's no need for me to be appointed.
Yeah.
But if they don't, something about picking him up or make some sort of arrangements or something, I hate for him to be sitting in jail.
He signed a
when he's
bond
paid
on the Florida case. He's got a bondsman.
What he's telling me is that he's paid some $5,500.
Yes, sir.
All right, well, why don't we ROR him on the extradition one?
All right, Judge.
Okay?
Yes, sir.
You
Thank
guys,
you, sir.
you guys take care of Florida first,
Yes, sir.
okay?
Yes, sir.
So you got public defender, get with him. We got you set for April 22nd.
All righty. Sir, I'm going to give you a card. If you get out, which I anticipate now that you will, what I want you to do is I want you to call the number on this card, make an appointment to come see me, okay? Take two of them, put one of them on the refrigerator. For some reason, that one doesn't get lost.
Yes, sir.
Okay.
So for a better understanding, what is taking place right now, Your Honor?
You're being released on your own recognizance on the extradition charge. You've already made bond, you've informed us on the other charge, so there should be nothing else holding you.
Yes, sir. I thank y'all.
Okay?
If there is, let me know and
Yes, sir.
we'll deal with it.
Yes, sir. I thank y'all.
Okay. Curtis Jones.
Oh, I did.
You did.
Curtis Jones out of custody?
No.
No?
Judge, I've got a Curtis Jones.
Yeah, Curtis Jones.
I'm not showing him as being in custody. Information has been filed.
No bond capias. Sandy Pine? This is 24 CF 506. Mr. Pine, you're charged with fleeing and attempting to elude drugs possession without a prescription and resisting an officer without violence.
Your Honor, we're going to enter a not guilty plea today, request trial by jury. I do think we're going to be able to work this out, so if we could put this on the next available court date. April
April
22nd.
22nd.
Okay.
Gregory Spears.
She's not here. Because I tried to get her to see if she'd agree, but she wouldn't. She said she's gone for the afternoon, and we'll have to get back with her.
Ms. Rivers. Gregory Spears.
Yes, Your Honor. Mr. Spears is before the court on 24 CF 532. We're going to tender a not guilty plea at this time and request trial by jury. He has 2 VOPs, and I'm just going to ask that they all run together.
April 22nd.
Yes, Your Honor.
Alex Stanford. Is it Alexis?
Yes, sir.
Alexis Stanford? 24 CF 513, you're charged with possession of a controlled substance, no improper vehicle registration, a financial responsibility violation, possession of narcotics equipment, and driving license suspended. Is there an offer?
Yes, it's an alternative offer. Either a PTI with a plea, and that would include probation of 12 months, substance abuse evaluation, and then no alcohol controlled substance, 50 hours community service, and court costs. Or she can get, as charged, withhold of adjudication and court costs. No probation.
You want that? If you want to plead to those charges, I'll withhold adjudication of guilt, which means you don't have a conviction.
I have no idea. I haven't spoken to an attorney yet.
Appoint the public defender, April 22nd. Thank you.
I asked what your name was, so we
okay,
know
I'm
which
sorry.
attorney was going to be handling.
You're fine. I haven't heard my name being called.
Anthony Weeks. Charged with, this is 24 CF 498, failure to register. And
What's his name, Your Honor?
Anthony Weeks.
Oh, yes. So the offer would be plead as charged, adjudication of guilt, 12 months on community control with GPS monitor, cost of prosecution, court costs, and register as required as a sex offender.
Your Honor, I'd like to plead not guilty on that. And when I went to register.
Hang on one second. Don't tell me about it because they'll use it against you.
Yes, sir. You're
I'll appoint poet defender.
Your Honor,
absolutely.
we're going to
Thank
enter a
you.
not guilty plea and request trial by jury.
April 22nd. All right. Did we have Naomi Cantrell?
Still seeing no response, Judge, from the well.
All
Or from
right,
the gallery.
no bond capias.
Understood.
Y'all want to start the 2 o'clock one?
Judge, it's Ms. Sandler's. Well, mine is Ms. Sandler's case.
I think I need,
coordinated with
I think
the
I need
prison on
Zoom
that,
set
so
up.
we're gonna probably have to wait until 2. Yes, I am. Absolutely.
Is it this two you gave me?
Yes, it is.
Okay. I'll give you the score sheet as I get called.
Okay. Good. This will be in addition to the violation of probation.
This is 17 CF 2429, State of Florida versus Roy Howland II. You want to admit that you violated probation, Mr. Howland?
Sir.
Would you raise your right hands, please, to be sworn? You swear the testimony you give for is course of truth, so help you God?
Yes, sir.
Did you read and sign this admission form?
No, he's not signed it yet. Sorry. There's no pass-through for me to hand it. I've signed it, but in the state signed it. Oh, here. You sign it. Do you mind if I date it for you, sir?
No, sir. Sorry.
Yeah.
Sir Howland, would you raise your right hand to be sworn? You swear the testimony you give for is course of truth, so help you God?
Yes, sir.
You want to admit that you violated probation?
Sir.
Did you read and sign this admission form?
I did.
Are you aware of the rights you're waiving by entering this admission?
I am, sir.
Anyone force you or threaten you to enter this admission?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, thank God.
Are you happy with the work Mr. Williams has done for you on your case?
Yes, sir.
Court finds the admission freely and voluntarily entered. Court accepts it, adjudicates you guilty, sends you to time served. Is there any court costs and any of
Well,
that?
Judge, this is a violation of probation, so he's got some, he may have some outstanding costs that are owed. Those will just need to go to collections.
All costs to collections. Thank you. Revoke and terminate probation.
Thank you, sir.
Thank you.
All righty, good luck to you.
too.
Okay?
So that's
Oh, you
okay.
need a, you want one of the cards. There you go, sir.
And I got paperwork.
Well, I tell you what, if you want, I'll give you one of my copies. How's that?
Okay. Always good to have paper.
Okay.
Thank you,
There
sir.
you go, sir. Okay, thank you. All right, Ms. Jones, let me get your signature right there. Now, you take it you haven't changed your mind in the last 5 minutes?
No.
Okay. Mind if I date it for you?
Please do.
All right.
This is who?
This is going to be a plea to two cases, Judge. 4623 CF 269 and 24 CF 702.
Ms. Jones, would you please raise your right hand and be sworn? You swear the testimony you give for is course of truth, so help you God.
Yes, sir, I do.
And this is 23 CF 269 and 24 CF 702. You want to enter a no contest plea to the charge of possession of a controlled substance under 269 and possession of a controlled substance under 702 and possession of paraphernalia under 702. 2 third-degree felonies and 1 misdemeanor, correct?
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
I did.
You aware of the rights you're waiving by entering this plea?
I'd have.
Has anyone forced you or threatened you to enter this plea?
No, sir, they
Are
haven't.
you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Mr. Williams done for you on your case?
Very pleased.
Court finds the plea is freely and voluntarily entered. Court accepts it. Adjudication is withheld since your 2 years probation. Attend ECLC while on probation.
Yes, sir.
$518 costs, $100 cost of prosecution, $50 PD fee, $50 PD app fee, $100 PD fee, concurrent on count one on each case.
Yes, sir.
Thank you,
And on
Judge.
count two, 24 CF 702, sentence you to time served.
There you go. All right,
Thank you.
ma'am. You take care.
Yes, sir.
Waive cost of supervision.
Supervision fees waived, Your Honor.
Yeah.
Your Honor, I believe all the parties are present on Jacob Daniel Price.
Let's see.
Did they bring him back?
Where is he?
Bring him right now.
Do y'all have a copy of that report that I can?
Is this my case?
Yeah, yeah. Well, I want to see the doctor's report.
No,
So-
sir, that's the motion.
I'm assuming you're fine.
The doctor's report.
Hey. All right, this is State of Florida versus Jacob Daniel Price, 2019 CF 3106. This is Department of Children and Family Services, motion to intervene and vacate order adjudicating defendant incompetent to proceed and commitment to the Department of Children and Families. I reviewed Dr. Zeman's report, and my interpretation of his valuation was, and it was a rather comprehensive valuation, was that he is not competent to proceed.
Yes, Your Honor. Good afternoon. Laura Battaglia, Assistant Regent Counsel with the Department of Children and Families. Your Honor, the department filed the motion to vacate, not necessarily because of the incompetency issue. We're not disputing that Dr. Zeman determined that this individual does have a mental illness and he lacks competency. The concern for the department was the commitment to the department, so commitment for inpatient treatment. Dr. Zeman did not reach that conclusion in his evaluation. He had indicated that Mr. Price was not a danger to himself or others, and that community treatment was an option. Or, if not available, I believe.
If not available, what?
Treatment in the jail. So we're just asking that the court vacate commitment to DC.
What does the state say?
Your Honor, the state's opinion after consulting with the jail and looking at Mr. Price's history, Michelle Sandler for the state of Florida, is that the court can't piecemeal an order. I know that the case law is very clear that the department can't appeal a finding of incompetency, and that they have filed the appropriate motion by trying to intervene. But what the state thinks the court should do is perhaps vacate the entire order and order a second evaluation to see whether or not that evaluator finds that he meets criteria. Mr. Price is charged with murdering both of his parents and 2 dogs.
Yeah, I know.
So I find it very, I'm sure the evaluator is going on that he's been in a secure setting, and that's why he doesn't present a danger to himself or others at this present time. Obviously, Mr. Price cannot be released. The state has looked into what competency training would be available at the jail, and right now there is none. Mr. Barnes doesn't go to the jail currently for competency restoration. The jail is open to competency restoration, but we'd have to figure out how.
I'm gonna order
that's gonna happen.
another valuation then. Okay, you still be held in jail. So prepare me an order.
The state will prepare an order for a second evaluation, and we'd ask for the appointment of Robert Klein III.
Pardon?
We'd ask for the appointment of
Okay.
Robert Klein III.
All right, if he's on the list.
He's on the list, Your Honor.
Okay. All right, we'll do that. See what happens there. Okay?
May I approach for the?
Oh, yeah. Here's that motion. He's still held under no bond.
Yes, Your Honor.
Thank you. All right, what do we got next?
Judge, I'm here on Keith Jesperson. This is a plea on a second-degree murder.
Is that going to be through Zoom?
It is, Judge.
It is, and Your Honor, he would not be available until 4 o'clock based on the time difference. The state just got that email late yesterday afternoon because he's all the way in Oregon. They have a special Zoom room. They could do earlier today, but the court already had other things earlier today.
All right, we'll come back at 4 for him then.
But I believe there's other things on the docket
There
between
are.
now and then.
What else? Christina Beeman, we got that one?
Well, let me check and.
That's with Mr. Gibbs, Judge. I think he stepped out to speak with her.
And what the state can do is check with the Oregon Department of Corrections and see if there's any way they can get him on earlier since the court is available earlier.
I got to make sure this, pardon? And every time I've tried to do Zoom, it doesn't work very good.
Good afternoon, Your Honor.
All right, this is 21 CF 1526, State of Florida versus Christina Elaine Beeman, sentencing on a DUI manslaughter.
Correct, Your Honor.
Go ahead.
Thank you, Your Honor. As the court may be aware, we did file a motion for downward departure yesterday, putting forth 3 grounds. 2 of them are statutory reasons for departure. The other remaining ones are non-statutory. Judge, we do recognize that she scores, as charged, 124.5 months in the Department of Corrections on a presumptive sentence based on the charges and the additional points that were added due to a death occurring. We are asking for a downward departure, Judge, for a sentence that focuses on supervision. In the time since this happened, she has been working at Taco Bell here in town. She has been working there full time. Her manager is here, her area manager is here. I do expect to call her as a character witness if the court would be so inclined. She also has other team members here, as the court can be aware, sitting in the gallery, here to support her, here to hope that she gets the best outcome that she can from the court. She has also been on a scram monitor for the entirety since June of 2021, since she was released from jail. She's had 0 violations on that scram monitor since her release. She's also been, she's prepared to as well testify about any counseling that she's undergone, as well as any other mental health concerns that she has had since this incident occurred. And I'm happy to go through the grounds set forth on my motion if the court is so inclined.
State have any witnesses?
No, Judge.
All right, go ahead.
Your Honor, the first ground that we have in our motion, we're asking the court to find a downward departure that the offense was committed in an unsophisticated manner and was an isolated incident for which the defendant has shown remorse. Judge, the information that we would put forward to the court that this was that this was done in an unsophisticated manner. Judge, the evidence that was obtained through discovery is shared between ourselves and the state. In this case, Ms. Beeman did indicate that she had consumed alcohol earlier that day as well as marijuana. However, according to the law enforcement officer, the two troopers that were there, they did not see any signs of impairment. Neither of those two troopers saw any signs of impairment, weren't even trying to investigate a DUI at the time of the crash. Ms. Beeman did indicate that she may have been traveling over the posted speed limit. The estimates from FHP were that she was driving anywhere between 50 and 60 miles an hour on a 45 mile per hour speed limit area on Highway 4 in Baker, just north of Milligan. But she indicated to law enforcement at the time of their investigation right after the crash that she was not able to see the motorcycle in time to swerve, and the only other vehicles she was able to see were the vehicles traveling in the opposite direction. We note that it was dark outside, there weren't any street lights, and that the deceased, Mr. Mills, who met his tragic, unfortunate, untimely end, was traveling very slowly and that the lights of his motorcycle may not have been on. Two witnesses that FHP spoke to indicated that they did not see the lights of the motorcycle were on. One witness said that he believed that the headlights of the motorcycle were on. Ms. Beeman was traveling behind the motorcycle and hit it from behind. We may not be able to determine whether or not Mr. Mills' motorcycle was indeed broken down, or whether he was pushing it or riding it, because the damage to the motorcycle was so great that we can't tell what damage it may have had before the crash. We'd also put forward, Judge, that there was just no plan. She wanted to get home. She wanted to eat dinner. She had just come from a funeral of a dear friend that had passed away earlier, and she was trying to get home, get back to her children, or get back to her life, get back to dinner. We'd also put forward that this was an isolated incident. As far as we're aware, Judge, the only priors that she had, the first prior mentioned by the state in their sentencing letter is from 2020. It was a petty theft. Believe she actually worked to resolve that, worked very quickly to resolve that. Adjudication was also withheld. The only other prior that I found was a driving on a suspended license charge from 2012, again, where adjudication was withheld. So we'd, of course, make sure that the court doesn't take any consideration into that in determining sentence beyond any points that may be assessed on the score sheet. That makes this isolated, Judge, in the essence that she's never been charged with any crime like this before. We also believe that, Judge, that she's shown remorse in her actions. It has taken 3 years to resolve this case because it's gone through different attorneys, because we've had different issues come up. But she has been affected by what's happening. I believe she's been in counseling since then. She has been on medication for her mental health reasons that she's had. We were actually trying to look into how to place one of those drive safely signs that you see on the highways to mark memorials of accidents that have unfortunately claimed the lives of motorists. She's been working on her mental health, again, as she goes through, and she's definitely shown remorse, and again, she's prepared to testify today. The second ground, Judge, probably a bit more tenuous in the sense that she cooperated with the state or really law enforcement to resolve this. Initially, as I said, law enforcement, the two troopers saw no signs of impairment, from Ms. Beeman during their investigation immediately following the crash. Ms. Beeman did go to the hospital. She provided a blood sample. I believe a court order did come out for that blood sample, but she did provide it voluntarily. So essentially, we wouldn't be here if she didn't provide that blood sample. There's more argument in the...
Mr. Darren, we won't need you for a while.
I'm sorry?
We won't need you for a while, Mr. Darren. Thank you. Go ahead.
Okay. And then otherwise, Judge, on the non-statutory mitigating factors, we did want to point out that based on the depositions we had and the other discovery evidence that we received, Mr. Mills had 1,900 nanograms per milliliter of methamphetamine in his system at the time of his death. He was very likely under the influence as well. He was, again, in a dark area, wearing dark clothing, driving a dark motorcycle or pushing a dark motorcycle on a relatively busy street at the time. He essentially also contributed to the circumstances that created this incident. And therefore, Judge, that's why we're essentially, those reasons are why we're putting forward to ask the court instead sentence her to give her a sentence that focuses on supervision. Again, Judge, Ms. Beeman is prepared to testify, and I also have her area supervisor, Ms. Gail Ferris, present, willing to testify.
does the state say?
Judge, if we're going to proceed to argument at this point, then I'll go through. We filed a written letter with the court. Your Honor should have received that already, our sentencing letter with a recommendation of what we believe would be appropriate within this case, Judge. Now,
All right, well,
so,
if you want to wait on argument, do you want to wait till after you hear any witnesses?
yes, Judge.
All right,
Your Honor, first I call Ms. Beeman.
come on up. All right, Ms. Beeman, when you get up there, would you raise your right hand to be sworn? Go ahead.
Can you hear me okay, Ms. Beeman?
Yes, sir.
Can you state your name for the record, please?
Christina Beeman.
You understand why we're here today, right?
Sir.
So, obviously you've been charged with DUI manslaughter. So we're talking about essentially what happened. What I want to know from you, what was going through your mind that night?
Earlier that day, I was at a funeral for a childhood friend, and I'd driven home to Brandon's house on Highway 4. That's why I was in Baker.
Who's Brandon?
Brandon's my partner. I've been with him for about 5 years now. We ordered dinner through DoorDash to my parents' house where my children were at, and we were gonna eat dinner once we got there. I'm sorry.
Take your time. So you were going to your parents' house, right?
I was heading back home, yes, sir.
When was the funeral earlier that day?
The funeral was at, I think, like around noon, 1 o'clock.
Okay. What time did you leave the funeral?
I left about 2, 3 o'clock.
What time did you leave to head back home?
Probably about 6-ish, 6:15-ish, somewhere.
So were you going through Baker or Milligan around 6:15-ish?
The accident happened somewhere in between 6 and 6:30. I started dissociating pretty hard after the accident, so I'm not exactly sure what time it was.
What do you mean dissociating?
It's like a feeling when you're watching your body move from the outside. You're not in control of your body, like your brain is telling your body to do stuff, but it's not sending to your body. You're not doing what your brain is trying to make it do when you're watching from the outside.
Do you feel like more of an observer in that situation?
Yeah, it's like a third-person view.
How do you know that information? How do you know that feeling?
I've been in therapy for a long time. I was first diagnosed with PTSD when I was like 16. So it's something that's happened on and off throughout my teenage and adult life. You don't ever really stop having things like that. You just kind of go through enough therapy to work through it.
Are you still in therapy or counseling?
Sometimes on and off. I'm having a hard time finding therapy right now because it's expensive, and I've been paying for my supervision, my scram bracelet, which is pretty expensive, and my family just moved into a new house, so bills have gotten higher, and I can't really afford therapy or medicine at the moment.
Are you going as often as you can?
When it's like an emergency and stuff like that, I know when to reach out and to get help.
Were you in counseling or therapy following this crash?
I went with Cerebral, which is an online therapy for a little bit. I went for maybe like 6 months, but I couldn't afford it anymore after that, so I had to stop.
What all do you remember from that night during the crash, after the crash? What all do you remember?
I remember most of everything. Some of it I remember like crystal clear, like I can still smell what the outside air smelled like. I was driving and like I couldn't even tell you what song was on the radio. I wasn't smoking a cigarette. We didn't have the windows down. My partner Brandon was in the passenger seat with me, and we weren't even having a conversation. I was just looking at the road, and all of a sudden, I hit something and the windshield shattered, and I looked over at Brandon and I said, "What just happened?" And that's when the airbags went off. And he said, "Baby, pull over. We just hit someone." And I pulled over immediately. He had rolled over the top of my car onto the trunk. And when I got out, I was trying to call 911, but my cell service wasn't going through. I think it's because a lot of people at the area were trying to also call 911.
Were there other vehicles on the road?
Oh yeah, everybody that was around when it happened, everybody stopped. And
How many vehicles did you see traveling the opposite direction right before the crash?
I don't really remember, but I don't think that many. If anything, I don't remember specifically, so I don't think that much.
Do you remember seeing if there were any lights on the motorcycle before the collision?
When I stopped my car and I opened up the door to get out, his motorcycle was right by my open car door, and the bike wasn't on. There was no lights. There was no sound. There was nothing. His motorcycle was off, and there were no lights on his bike.
How did you not see him before the collision happened?
He was wearing all black. He had on a black helmet, a black, I think, leather outfit. There was nothing reflective. I didn't see him until he was already on the windshield.
Was it dark outside?
Yes, sir. It was in the beginning of January, so it gets really dark at that intersection. There's not a lot of street lights there.
Have you been working since this happened?
Yes, sir.
Where have you been working?
I've been working at the Taco Bell by Walmart. I've been working every day since a week after I got out of prison. I went from being crew up to being the first assistant paid salary.
How has this affected you mentally?
I don't eat. I don't sleep. I feel like I'm not supposed to take care of myself because of what I've done, and even if it's an accident, it still happens and it still hurts everyone. So part of taking responsibility of that, sometimes I treat myself worse than I'm supposed to try to make up for everything, even though I know it's never going to make up for it.
You wish this never happened?
I wish so many things. But you can't take it back, and you can't focus on wishes. You have to worry about what's happened and taking responsibility and accountability for your actions, even if you didn't mean for them to happen. That's why I've been nothing but honest and open this whole time. I've made sure that I've always told the truth.
How much alcohol do you remember consuming before you drove that day?
We had a few shots of Jaeger at the funeral, somewhere around maybe 2 or 3. And then when I got to Brandon's house, we had a couple of those gas station Seagram's Jamaican Me Happy, 8% drinks, and then we hung around for a good while.
Do those come in 12-ounce bottles?
They come in cans, and I think they're 12-ounce maybe. I haven't touched any of that stuff in 3 years, so I don't really remember.
Have you stopped drinking?
The bracelet monitors if I drink or not, and if I drink, I violate. But after the accident, I couldn't drink if I wanted to. It makes me sick to smell it. I literally throw up, and I get real panicked, and the rest of my day's pretty much over. I have to get back in bed and mostly just sleep so that I don't ruin everything.
Is there, did you consume any marijuana or hemp or CBD or anything like that earlier that day?
I smoked about a blunt, maybe like a 0.5 or a 0.8 of a gram.
Was that blunt, was that medical marijuana? Was that a Delta? What was that?
At the time, I didn't have my medical marijuana card.
Okay.
So it was just like regular, I guess you could say, street weed. I did also smoke sometimes the vapes that you could get from like the gas station.
Do you know if the weed in this blunt came from a gas station?
I don't think so, no, sir.
Are you aware of the results of your blood tests that were taken?
I know that they said that there was THC and Delta 9, I think, was in there.
Is there anything that we haven't talked about that you'd like us to know?
Before the accident, I was battling real hard with my mental health as well, and I was a fully functioning alcoholic. I drank all the time, which I know I shouldn't have been doing, but I was at such a high level of functioning that I could still get everything done and no one even knew. And it was a real problem. My family was mostly taking care of my children, even though it wasn't their responsibility. And then after the accident happened, and I've stopped doing absolutely everything except for going to work and going home to my kids and being a mom. Neither of their biological fathers are in the picture. I have two kids. They're 7 and 9. And I've completely turned absolutely everything around. I'm the only one that can keep my family together the way that they're supposed to be. And I understand the weight of what I did. I could never take that back, and I don't think I would want to. Because taking responsibility for this means that Eric won't ever be forgotten. He won't ever be erased from here because I'm going to carry him with me always, regardless of what happens. I'm trying to pick up the pieces of everything, and I would just like to ask if I could try to stay free while I do that so I can keep taking care of everybody, even though I know I don't deserve to ask for anything.
Thank you, Ms. Beeman. I don't have any other questions.
Do you have any questions, Ms. Davis?
So, Ms. Beeman, you said that you were a fully functioning alcoholic before the crash.
Yes, ma'am.
Okay, so does that mean that you typically drove after you would drink alcohol?
Not like, okay, so fully functioning alcoholic to me means that you start drinking in small increments from the time you get up to the time you go to bed, kind of just to keep your body well after a certain point.
And so would you drive after you would drink?
Not usually, but sometimes if you, like in the earlier mornings, but never further on in the afternoon.
I don't have any other questions.
All right, thank you. You can step down. Next witness.
Your Honor, I'd call Ms. Gail Ferris.
Thank you, ma'am. Have a seat.
State your name for the record, please.
My name is Gail Ferris.
Do you know Christina Beeman?
Yes, I do.
How do you know her?
I've been employing her since 2021.
Is that when you first met her?
Yes, sir.
When about in 2021?
I believe it was the beginning, around February-ish, and so forth.
So that would have been likely after this traffic crash happened?
Yes.
How did she present to you?
She presented well, just, she actually came before that, I guess, shortly after the accident. She was employed. I didn't hire her directly because I was the area coach. So she came to us as an employee in that, and then she left for a short while. Immediately after she got out of prison from this situation, she came back. We gave her a job. I didn't directly relate with her for probably 6 months after she was there, and got to know her better. And then I really didn't know about the details of this for probably about 6 to 8 months after she was employed with me. And that when I noticed she was having some emotional concerns. And so at one point, I took it upon myself to ask her detailed questions of what was going on with her life. And she shared with me at that time what was going on.
How's her work ethic?
Her work ethic is amazing. It's unmatched, is what I can say. From the moment that I found out what she was going through and things of that nature, we've had a business and a personal relationship on a Christian level on my side, in that I watched somebody who was suffering very much emotionally and things of that nature. And I guess I took it upon myself to try to recenter her a little bit and take her away from the hell that she was living and bringing to work, and trying to get her to separate the two, to take care of herself for her family and things of that nature.
From your experience in interacting with her, how has she handled this incident?
Ooh. Part of me has to say not well. I mean, I've watched her suffer emotionally, mentally. I've talked her through many a day to try to focus on the here and now. She was trying to weigh her family and get herself back on the tracks. I remember all of her court hearings. I believe it was every 3 to 4 months for all these years, and I would make sure she had time. She made sure that she didn't miss anything. We accommodated her. She's suffered quite a bit. You know, it's just hard for me. I understand what's happened in that. It's just I've watched somebody who can't let this go in that, and it was a very fine line for me to work with her in that, because I'm trying to operate a business and I'm trying to take care of her emotional in that. But we do have a very good relationship in that she does tend to listen to me when reality comes to play, and when she gets to the point to where she doesn't think that she should take care of herself because of what she's done. I've been able to recenter her in the here and now and have her remember what she has, which is her children.
She works full-time, is that correct?
She works full-time.
So 40 hours a week?
Yes, sir. I promoted her to a salaried assistant manager with a very good salary to take care of her family in February of 2023.
And is she on track for more promotions down the line?
Yes, sir. I was looking at her to take the restaurant for me one day.
Is there anything else about her that we haven't talked about that you think we need to know?
I guess the only thing that I can say is I've watched the remorse. I've lived the remorse with her and things of that nature. It's taken a lot to try to keep her centered on a day-to-day functioning in that. And I don't know. It's hard to say, you know. I mean, she punishes herself every day is all I can say. I watch it, and it's really hard for me sometimes to tell her that she has to put that over here for now and try to get in. And because of that, she has had a very good year, and when I promoted her, she works more than anybody else. She's available 24/7. She never lets us down. She's very dependable, and I don't know what else to say. Everything she says is true. She punishes herself more than anything, and it took me a lot to make her understand that she has enough of a life to live to take on everybody else, because that's what she tends to do. She wants to take care of everybody else's problems, and that makes her forget hers.
Speaking of everybody else, I noticed there's a lot of other folks here in the courtroom today. Do you recognize them?
Yes, sir. They all work for me, and 2 or 3 of them are prior people who worked for me.
So they've all worked at the same store?
Yes, sir.
Y'all kind of close like family?
Yeah, we're a very tight-knit family.
Are they all
I'm
here?
blessed.
Are they all here to support her?
Yes, they are. Yes, they are.
Thank you, Ms. Ferris. I don't have any other questions.
Thank you.
Thank you.
No questions, Judge.
Next witness.
I have no other witnesses, Your Honor.
All right, argument.
Your Honor, as we said before, one of the main focuses that we're going for as far as a downward departure is that this was, this offense was done in an unsophisticated manner and was an isolated incident for which the defendant has shown remorse. In the testimony, we've also heard from Ms. Beeman as well as Ms. Ferris today. Ms. Beeman has been beating herself up about this every single day since this happened, and we heard her own testimony. She doesn't know, even though she doesn't know if she would change it, it still has negatively affected her in the sense that she is struggling to pick up the pieces. She's trying to make a better life for herself, but she still wants Mr. Mills's memory to live on. That's why she's ready to take responsibility. However, focusing all of that together, a sentence that would focus on supervision that would allow her to continue her career with all of these people that have been here to support her, with her area manager that is here to support her, Ms. Ferris, wants to see her do well, wants to see her achieve success. A prison sentence would, at the very least, put that on hold, but in the worst case, it would destroy all of that. And again, this is a complete tragedy, but it's an accident. It's an accident, and I hate to say this, but it takes two to tango. And it was a tragic, tragic accident. But since then, Ms. Beeman has made positive changes in her life. She stops drinking. Alcohol makes her physically sick to even smell, to even be around. It makes her physically sick. Judge, this is isolated. Again, her only two priors that I can even find are a suspended license charge that was withheld in 2012 and a petty theft that was withheld in 2020. And she's clearly shown remorse based on how she's performed at work, her relationship with Ms. Ferris, and her own testimony. That's the main focus that we want to focus on. We also have the other grounds in our motion that were filed, Judge. We are asking for a supervision-based sentence. We have no objection to a suspended sentence if the court finds that appropriate. Her maximum is 15 years. She does score 124.5 months. So anything less than that would be considered a downward departure. We believe she qualifies, and we believe it's appropriate under the circumstances.
State.
Judge, as far as the grounds for departure, I'll go ahead and just, as far as count 2, I do have case law regarding that. I would really appreciate it if Mr. Gibbs can walk it up there.
Your Honor, Ms. Davis did give me this case earlier. The reason that we had filed the ground 2 for the cooperation in the sense that had she never given this blood draw, we wouldn't be here because the troopers didn't see any signs of impairment. I believe the case law, Ms. Davis, she can explain that, of course.
Judge, under that case law, if you look at the second page of that, on the left-hand column, the beginning of the paragraph at the very end, it says, while cooperation with law enforcement is a valid ground for downward departure, the actions here in not requiring the officers to obtain a search warrant to search his home and in giving a statement to officers did not rise to the level of cooperation that is required in order to justify a downward departure sentence. So, Judge, I know the facts of this case are a little bit different, but I think the reasoning of the holding is the same. We've got a case that the defense's argument is based on the fact that Ms. Beeman gave a voluntary consent for the blood draw, and then that she gave a statement to police. So I think it's still going to be the same thing that we're talking about here. So I think with the case law, that particular ground, something that the court can't use in determining a downward departure in this case, Judge. Now, as far as the grounds 3 of the non-statutory mitigating factors, none of these have been approved by case law. And in fact, we've been told by the appellate courts that comparative negligence is something that can't be taken into account, and that the victim's cooperation that can't be taken into account. So we'd ask that Your Honor not consider those grounds in making the determination for today. So I'm going to focus my argument as far as rebutting ground 1 for the downward departure argument, and from there, the state's argument is encompassed within the sentencing letter as far as our position with the case. But as far as this particular ground for downward departure, the court knows that this is a two-part thing. Can the court downwardly depart and should it downwardly depart. And in this particular case, it's the state's position that this ground has not been met for that first prong of can the court downwardly depart. So when we look at the first part of it, the offense was committed in an unsophisticated manner. Now, we heard testimony from Ms. Beeman just now that she said that she was a functioning alcoholic, which means that she worked pretty hard to cover up the fact that she was consuming alcohol on a daily basis, and even would typically, or maybe not typically, but she would sometimes drive intoxicated. So this is something that was not just an accident that she just stumbled upon doing. In fact, she was doing this on a regular basis, according to her own testimony today. So from the state's perspective, this is something that has not been proven. Now, I see that there were some other things that the defense put into that portion of it, like that the troopers didn't even know that she was intoxicated, that, you know, there's clear in the report that it was noted that she smelled like alcohol. She had difficulty walking to a law enforcement vehicle at some point. So I don't think that we can stand here today and say that this was a case that would have never come before the court for a DUI manslaughter had she not volunteered, and that this was something that just was a happenstance occurrence. So they also go through in this part of it that, you know, she wasn't able to see the motorcycle in time to swerve, but she may have been driving too fast, and so she didn't see anything. Well, that's the entire point, Judge, of not driving when you're intoxicated, is that you can't adjust and deal with hazards in the road. So a motorcycle that's driving slower than you, driving over the speed limit, then that's the entire point. You don't have the reaction ability to do anything about a potential road hazard. And then there's another point in here that we don't know whether Mr. Mills's motorcycle was damaged or repaired. We'll never know. Well, that's because she killed him. He can't speak today, Judge. We do know from other people that were on scene, there is a statement from Mr. Daniel Carney that he said, yes, it was dark outside, and the only lighting around was from headlights, which he stated both vehicles had their headlights on. He said that he never observed brake lights. So the statements as far as there not being lights, he didn't see brake lights. Now, so, you know, other people were able to observe this motorcycle on the roadway. There's multiple other people that could see the motorcycle on the roadway. The difference is this defendant was intoxicated at the time of the crash and was not able to correct herself when she came up too fast from behind on a motorcycle. And then I'll move on to the next point, that the offense was an isolated incident. You know, she gave testimony today that this was not the first time that she had driven intoxicated. I think we get lost a lot of times in focusing our arguments to the court on isolated incident as far as past criminal history, because oftentimes in criminal court that becomes a bar to this even coming into play as being an isolated incident. That we're talking about someone that has extensive history, and so this can't even be considered. But that's only something that's part of case law. We still have to consider that this is still a ground that has to be proven by the defense. And the state would argue that that ground has not been proven based upon the defendant's own testimony today, that this wasn't an isolated incident. She had driven intoxicated other times before this. This is just the first time that she got caught, because as she said, she was a functioning alcoholic and tried to cover up that she was drinking all the time. The last thing is, as far as the defendant has shown remorse for her actions, I think today, I'm not going to say that she does not feel remorseful. I do think that there was a mixture of remorse, but also sorry for herself, is what it sounded from the state's perspective today. But that's not something that I necessarily want to dwell on at this point, Judge. So the score sheet says that this defendant, her lowest permissible prison sentence is 124.5 months. We'd ask that it be imposed today, Your Honor. There is 4 years of that will be a minimum mandatory because it is a DUI manslaughter. There's a reason that these 120 death points are included in the score sheet, Judge. That's because there is a victim that is not here and not able to put his perspective on the record of what he believes is the right thing to do in this case. That's because this defendant hit him and killed him.
Anything further?
No, Judge.
Mr. Gibbs?
Your Honor, if I may respond, thank you. Ms. Davis talked about Ms. Beeman's testimony about being a functioning alcoholic at the time, but I do want to bring the court's attention. She hasn't drank since. She testified also that smelling alcohol makes her physically sick. Ms. Davis talked about the grounds regarding cooperation ground 2, and while even if the court finds that that doesn't meet that qualifying criteria, we'd still argue that it is still mitigating, that she wanted to ensure justice. She didn't want to hide anything. I don't think she's tried to hide anything here today. She's admitted that she's a functioning alcoholic, or that she was a functioning alcoholic. She's admitted to drug use. She's admitted to illegal drug use. She's admitted to doing all of these horrible things. But since this happened, since this unfortunate event, she has changed her life around. She has been trying to seek counseling as much as she can. She has been trying to do better. She's been trying to be better. And indeed, maybe she is beating herself up. Maybe she deserves to. I'm not here to judge that. I'm not here to say that. But she's clearly been affected by this and has clearly been trying to make better and positive changes in her life and the lives around her. Ms. Davis also talked about troopers didn't know that she was intoxicated, but noted that she smelled like alcohol, had difficulty walking towards a law enforcement vehicle. However, in that same report, that same trooper still noted that she didn't need assistance walking back to her vehicle, that she didn't have any swaying or any other signs of that nature. Ms. Davis said, that's the entire point of not driving while intoxicated. You can't deal with hazards in the road. But that's still unsophisticated, I would argue, Judge. Somebody becomes a functioning alcoholic, somebody gets into drugs, somebody gets into addiction because they're coping with a mental health issue that hasn't been fixed, that hasn't been resolved, that isn't being treated. So she's coping to survive in that point. She testified earlier that she was a functioning alcoholic and would do little bits of alcohol just so that she could feel normal. That's what she was doing. This isn't one of those things where she's trying to plan and go out to kill people. She's trying to survive. She's trying to make a living. That's what was happening. Ms. Davis also talked about, the isolated incident issue, that this is not just past criminal history. However, she's still being open about it. Ms. Beeman's still being open about it. We want to focus on, of course, what happened since, because look at the positive changes. And again, remember Ms. Ferris's testimony that the work that Ms. Beeman has done, not only at work, but the personal work that the two of them have done together, the situations that Ms. Ferris has seen with Ms. Beeman and trying to help her cope with the post-traumatic stress of this incident and of other things in her life. Ms. Beeman's just trying to survive, and unfortunately, Mr. Mills is gone. And no, we don't ever want to forget that. She doesn't want anybody to ever forget that. We're not trying to let anybody forget that. But we're trying to help the court focus on the fact that her going to prison is not going to fix anything. If we can focus on a supervisory sentence, that is going to be in a situation where she is able to continue to be a productive member of society. Thank you, Your Honor.
I have the score sheet if Your Honor would like me to fill it out when Your Honor pronounces sentence.
I've got a score sheet also. I don't know who provided it to me. It was attached to...
I believe it was attached to the sentencing letter.
Yeah, we provided it with the sentencing letter.
And I have no objection to that score sheet. I've reviewed it.
All right, the state of Florida versus Christina Lane Beeman, 21 CF 1526. You're adjudicated guilty. I'm sentencing you to 124.5 months probation. Downward departure was 60 months. Department of Corrections suspended, 4-year minimum mandatory. Complete DUI school, attend and complete 3 victim impact panels, perform 100 hours community service work, minimum 50 hours with MADD, reserved jurisdiction for restitution 180 days, lifetime driver's license revocation, no drugs or alcohol, random UAs, 515 court costs, $5,000 fine. If you go to prison, it's your fault.
I want to make clear, it is a 4-year minimum mandatory.
On a suspended sentence.
So Your Honor is not imposing the 4-year minimum mandatory at this time?
No.
Thank you, Your Honor.
Judge, I want to make sure that my objection is noted on that.
And that's a downward departure for unsophisticated, shows remorse, and the court reviewed that case law and is aware of it, but feels there is just enough to qualify for the cooperation mitigation in addition to the unsophisticated manner, show remorse. I guess you got a couple of kids.
Sir.
You got people that care about you. This is a rather well, if you don't make it, you fail random UA, you're looking at 124, you're looking at 60 months in prison.
Yes, sir, that's
in
no
addition
problem.
to the probation. All
Thank
right,
you, Your
anything
Honor.
further?
Your Honor, just as a housekeeping matter, she is currently on the Scray monitor. I don't remember if the court ordered that as part of her sentence. I just wanted to make sure if it's not ordered that it can be removed today.
How long has she had that Scram monitor on?
Just shy of 3 years, Judge, without violation.
Can be removed after 2 more years, 24 more months.
Is that at no more than $1 per day, Your Honor?
Yes.
Thank you.
Yep.
Thank you, Your Honor.
All right, next case. We got the Oregon case next.
Yes, Your Honor. I've spoken to OSP in Oregon, and there's another hearing going on that's supposed to end at 2 o'clock Oregon time. If it does end earlier, they're supposed to call me right away and let me know that that room is available earlier.
Do I have any kind of paperwork with him, a signed plea form or anything?
Yes, sir.
We do have a signed plea.
We have all that?
Yes, Your Honor.
We previously provided one, a copy to the state. I have the one with his original signature on it in the file. That's all right, I'll just have a copy.
So it's not till 4 o'clock our time?
Correct, Your Honor.
Was there someone else that we were going to delay till this afternoon, or we take care of that already?
Judge, I don't have any more cases. Mr. Gibbs, do you have any other cases?
I do not have any other cases today, Your Honor. Thank you.
As far as I know,
I think there was one at 4, maybe, or?
we've handled everything.